Welcome back to Winning Isn't Easy. The any occupation stage, a tougher standard, and the game gets rougher. Now, after the own occupation period ends, most policies are going to transition to an any occupation definition of disability. And that's a much harder standard of disability. Now, the standard isn't whether you can perform your own occupation, it's whether you can perform any occupation for which you are reasonably qualified by education, training, or experience. Real world hiring, availability of work, and pay are irrelevant, as is your age. Now, there are factors that will dominate this stage in the carrier's analysis of your case. The first is going to be your residual functional capacity, and it's going to be reevaluated in light of your diagnostic studies, your exam findings, what your physician has to say about your restrictions and limitations, and what their liar for hire peer review doctors say about your restrictions and limitations, your residual functional capacity. The other thing they're going to be assessing is your transferable skills, and that is going to probably be as flawed as it was in the origins of this case. But here's the catch. The higher your skill level, the less transferable your skills might be. Though they'll play that one too. So a lawyer's litigation skills don't translate neatly to paralegal work because the duties are different. But many times I have seen them say that a trial lawyer, for example, could do other type of non-litigation work. Because after all, they're a lawyer, and any lawyer can be a lawyer, can be a lawyer, can be a lawyer. Now, I also see this game in retail settings. So you might be a retail manager or a district manager. And what they're going to argue is, while you physically may not be able to do the retail manager's physical occupational duties, you've got retail management skills that can transfer to management in an entirely different field. Carriers and vocational experts are going to lean heavily on tools like the Dictionary of Occupational Titles, specific vocational preparation levels, and other computerized tools that they will use to identify transferable skills and other occupations. That's really why it's important that if your claim has been denied, that you are involving not only an ERISA attorney, but a vocational evaluator who will be hired for the purposes of rebutting and taking apart the liar for hire carrier or plan vocational evaluator. What they're going to be doing is, again, arguing that your skills can be adapted to new roles, even when those roles are unrealistic, don't pay a living wage, and may not even exist in your geographic area. That's where many claims get denied or terminated. They're going to exploit vague policy language, rely on outdated vocational data, and ignore the practical realities of disability. Now, that can be an uphill battle unless you are prepared. And in my view, the preparation starts from the very beginning. You need to understand both the own occupation and any occupation definitions of the disability and occupation. You need to understand what it is you have to prove. Next, you have to determine what necessary medical proof should be supplied to the disability carrier plan about your residual functional capacity status rather. Are you going to use residual functional capacity forms that we Social Security lawyers have developed? Are you going to have a functional capacity evaluation? Are you going to have a CPET exam to measure your cognition and fatigue? How are you going to get your doctor to endorse these restrictions and limitations? You need to be thinking ahead because, again, you've got the burden of proof, and that proof becomes a whole lot harder at the any occupation stage. Now, remember, we've talked about in this episode a number of the tools that disability carriers or plans are going to use to create a denial or termination, and that strategy is going to start from the very beginning. That's just another reason why, in my view, you should be working with an experienced ERISA disability attorney from the very beginning. So not only you can deal with the challenges of getting your own occupation benefits, but you're anticipating a claim denial or termination at the any occupation stage. And believe me, I've had cases where the claimant has been on claim for 5 or 10 years, and all of a sudden the disability carrier or plan liar for hire doctor comes up with an opinion that this person has recovered or that they're able to do other occupations in the national economy. Why? Because they're tired of paying your benefits. They are looking for a reason to deny or terminate benefits. And it's very easy to create one at that transition stage from an inability to do your own occupation to any occupation, and then into that own occupation stage. Remember, they are not in the business of paying disability benefits for the life of the claim. They were happy to collect your gold in the form of premium, and they're just as happy as to rule that you aren't entitled to your disability benefits or that you've recovered so that you can perform your own occupation or any occupation. Now you understand the games? Good. Thank you for tuning in to this week's episode of Winning Isn't Easy. If you found this episode helpful, please take a moment to like our page, leave a review, share it with your family and friends, and subscribe to this podcast. Join us next week for another insightful episode of Winning Isn't Easy. Thanks for listening.